Advanced care plans and enduring powers of guardianship and even advanced health directives don't substantially change the clinician's role in delivering health care. While they're all about enhancing patient autonomy, particularly when a patient is not competent to make medical decisions at the time the decision is required, those instruments don't materially change the role of the clinician. So one of the challenges in a professional sense for clinicians is not to downplay or push their learning into the background, but to bring it forward in a way that contributes to the decision-making process. Perhaps the challenge is about communication. How can I, as a clinician, communicate my concerns for this patient, my sense of how this will play out, in a way that will contribute positively to decision making? But it's essentially a role of communication and of engendering trust, in my experience. There are also legal concerns around advanced care plans, enduring powers of guardianship, advanced health directives and so on. Now, one of the difficulties in Australia is that there is no national legislation. Each state has its own legislation, generally embedded in the Guardianship Act. In Western Australia, it's in the Guardianship and Administration Act. And back in 2008, a number of instruments were created to enable the non-competent patient to still contribute to their medical decision making. And they were the Advanced Health Directive and the Enduring Power of Guardianship. So in Western Australia, as an example, I can appoint a person to be my enduring guardian to make medical decisions on my behalf. Now, obviously, I should inform that person of my preferences. I can also, or as an alternative, create an advanced health directive. Now, in that directive, I need to state clearly what my wishes would be in certain foreseeable medical events. One of the challenges in the West Australian setting is that, on the one hand, advanced health directives are legally binding. On the other hand, the legislators have had to balance out the professional concerns of the physicians and also ensure best clinical care. So in the West Australian legislation, for an emergency admission or for life-saving treatment, even in the case of a suspected attempted suicide, a medical professional is able to provide whatever medical treatment they think is necessary, regardless of whether there is an advanced health directive or an enduring guardianship. In the West Australian context, there's also the capacity for a doctor who is unsure about the existence of an advanced health directive, or is unsure whether that directive applies to a particular admission. That doctor has the capacity to provide whatever treatment is reasonable in the circumstances, and that treatment is taken to be lawfully delivered, regardless of what's actually in the Advanced Health Directive. In other words, in the West Australian setting, clinicians retain a significant degree of professional autonomy and their capacity to provide best care according to their experience is untouched. If there's any uncertainty about whether that appointment is valid, or about whether the right person is available, or about whether the decision that they make is in fact in the patient's best interests, the clinicians, the health professionals, are entitled to provide whatever treatment they believe, whatever treatment in their judgment is best for the patient. I would say that one of the challenges for clinicians, healthcare professionals, is to be thoroughly conversant with the law applying in your jurisdiction. It's critical that good legal advice is taken from lawyers who are experienced in medical matters. Good legal advice is taken to ensure that everyone who is involved in providing care for a patient who has an advanced health directive or an enduring guardian, those health professionals are confident that they can make the right decisions and can go about their work unencumbered with fears about potential litigation. The third kind of concern that health professionals might have are ethical concerns. And particularly for clinicians working in Catholic acute care or aged care settings. Now, this is a complex area in some ways. In other ways, it's very simple. What is essential, though, is that all of our caregivers, from the administration, the executive, the clinicians, the nursing staff, everyone involved is fully conversant with the ethical standards that apply in Catholic health and aged care settings. So, for example, one critical starting point is, on the one hand, in our Catholic understanding of healthcare, we respect the dignity and the life of every person from conception through to natural death. On the other hand, we're comfortable with the idea that people die. Suffering, dying, and eventually the moment of death are normal parts of our human existence, and they're not to be held off at all costs. We can accept them. We, of all people who believe in the resurrection, can believe and be comfortable with the idea of dying. So, no, we don't have to keep people alive at all costs. Yes, we can allow people to die comfortably while providing them with good comfort and palliative care. Now, there are a couple of principles that help to apply this general balance to individual cases. One of them is called the principle of the morally extraordinary means of medical treatment. Now, that's a mouthful, but what it means is this: that any medical treatment can be classified as morally extraordinary and therefore optional if it fulfills one of three conditions. First, that the treatment offers no reasonable therapeutic benefit to the patient in the context of their overall health. Secondly, if the treatment is not reasonably available, so either geographically or financially. Thirdly, if in the patient's view the treatment would be unreasonably burdensome, and the notion of burden is quite wide. So in the event that a potential treatment option offers no reasonable therapeutic benefit, or is not reasonably available, or is unreasonably burdensome, then we are ethically entitled to reject that treatment, refuse to accept it, even if that means that my life will be shorter rather than longer, even if it means refusing a life-saving treatment falls under the same conditions. Clearly in this, the judgment of the patient themselves or their representative is crucial. They are the ones who make a decision as to whether a treatment is unreasonably burdensome. And burden can be physical pain and discomfort, it can be ongoing suffering, it can be a treatment which the patient would find morally repugnant, what I call the yuck factor. I just don't want to do that. It's a very elastic understanding of unreasonable burden. Now, we have to understand that all medical treatments carry a burden. Taking an aspirin carries a burden, it carries a risk. So we're not saying that all burden is unreasonable, but some clearly will be for the particular patient, and we need to pay attention to that. So a clinician need not apply a treatment if the patient says, no, I don't want it. Legally they can't, but ethically we're quite comfortable with saying, all right, the clinician thinks this is a good idea, the patient doesn't, we'll go with the patient. Ethical concerns in any setting tend to be primarily communication issues. So I would be encouraging clinicians to take up the challenge of first of all understanding the ethical context in which they practice, but secondly to make sure that they communicate well with all other participants in the community of care. It's the best way to ensure that good decisions are made. We need to share the responsibility, we need to share the information. The doctor's role is about providing the best possible advice in the best and clearest way so that the best decisions can be made. And I think if doctors are sure of their ethical ground and communicate well, then those concerns about advanced care plans, for example, begin to fall away. The last area of concern, I think, applying to health professionals are procedural concerns. So you're a doctor in a hospital, a patient is admitted and they have an advanced health directive, or they have an instrument appointing someone as an enduring guardian or with medical power of attorney. How do you know that? How do you know that they have that instrument, that they've made that appointment? There has to be some way of identifying which patients have those instruments, where those instruments are. Do we have a copy of the documents? Are the documents valid for this admission? And then how is all of that recorded and tracked through the patient's time in the facility? So I think it's critically important that health professionals in both health and aged care settings have the conversations necessary with the hospital administration to set up clear protocols around identifying, tracking and communicating the contents of advanced health directives, advanced care plans, or instruments appointing enduring guardians. St John of God Healthcare, when these laws were introduced in Western Australia back in 2008, St John of God Healthcare created a protocol for that very purpose. Essentially what happens is, at the point of admission, the patient is asked, have you appointed anyone with enduring power of guardianship, or have you made an advanced health directive? If they have, they're asked to provide the document to the admission staff. The admission staff pass it on to the nurse unit manager, and the nurse unit manager then becomes the hub of the process. So the nurse unit manager ensures that that document is recorded on the patient record, but equally ensures that the treating clinician, the admitting doctor, has a copy of that instrument. The same kind of protocol can apply to an advanced care plan, understanding of course that, again in the West Australian setting, an advanced care plan has no statutory authority, although it has standing in common law. But if a patient presents with a list of preferences written on the back of an envelope, it would be important that that list is kept, put on the record, and that again the treating clinician is informed of them. In the event that the patient becomes non-competent, it is very important that everyone in the community of care has a sense of the patient's preferences. If the patient has also appointed an enduring guardian, that person needs to be informed as well. So while there's no statutory weight to an advanced care plan, as distinct from an advanced health directive, it is important that we take account of them. They do have standing in common law, and in any event, they are an expression of the patient's wishes, and we ought to be listening to that. It's essentially a role of communication and of engendering trust, in my experience. In the West Australian context, there's also the capacity for a doctor who is unsure about the existence of an advanced health directive, or is unsure whether that directive applies to a particular admission, that doctor has the capacity to provide whatever treatment is reasonable in the circumstances, and that treatment is taken to be lawfully delivered, regardless of what's actually in the Advanced Health Directive. In other words, in the West Australian setting, clinicians retain a significant degree of professional autonomy and their capacity to provide best care according to their experience is untouched. If there's any uncertainty about whether that appointment is valid, or about whether the right person is available, or about whether the decision that they make is in fact in the patient's best interests, the clinicians, the health professionals, are entitled to provide whatever treatment they believe, whatever treatment in their judgment is best for the patient. I would say that one of the challenges for clinicians, healthcare professionals, is to be thoroughly conversant with the law applying in your jurisdiction. It's critical that good legal advice is taken from lawyers who are experienced in medical matters. Good legal advice is taken to ensure that everyone who is involved in providing care for a patient who has an Advanced Health Directive or an Enduring Guardian, those health professionals are confident that they can make the right decisions and can go about their work unencumbered with fears about potential litigation.